for the court's asking me to violate the privilege, I think, when the court says, tell me what your opinion was on something.
I don't think I'm asking you to violate anything because, first of all, I don't think a joint litigation agreement can protect you from your obligation of candor to the court. I also don't think it can inhibit the court from getting to the bottom of a discovery abuse and who participated in it and who authorized it. So, again, unless the lawyers want to tell me that they didn't participate and didn't agree that this subpoena should be issued, I'm going to assume everybody did. I don't see any distinction between what the lawyer culprit cases that you've tried to distinguish in this. This subpoena was issued by a lawyer for the benefit of at least one client, but it appears to me that it was issued for the benefit of all of the parties to this joint agreement. I think you're all subject to sanctions.
May I be heard when...
Ms. Layton, you have a lawyer, so...
yeah, but on behalf of my clients, I will want to speak.
Mr. Bivens is your lawyer, so that's my position.
Since I didn't know the court's reasoning until today, would the court give me and my firm an opportunity to brief this? Because
actually I didn't know about this joint litigation agreement until yesterday. So again, I've given everybody an opportunity to tell me why they shouldn't be sanctioned. So if you don't want to add anything else, you may sit down. Mr. Murphy, did you want to add anything to this discussion?
I have nothing to add, Your Honor.
Mr. Bivens?
Mr. Shumway, I think, and Ms. Slayton would like to address the court. And I wondered, did we lose the Siegelbaum issue here somewhere? Do you want to hear anything about that?
No.
Okay. Then I will ask my clients if they wish to say anything to the court.
I do, Your Honor. First of all, I assume I'll have an opportunity, with all due respect, Your Honor, to speak on behalf of Mr. and Mrs. Lund, because whatever happens today, I just want to put on the record affects my clients as well. So first I'll speak for myself, and then I will speak for my clients, because I have this feeling that I am in a sentencing hearing. I am being sentenced. I am being sentenced as a lawyer. This is my opportunity to present my address to the court. Okay, I have been a criminal defense attorney in my past, and I have said to my client, do you have anything to say to the court, or the court has asked my client before they're sent off to jail. So I want to speak because I believe in my 30 years of practice in the United States of America, I have never seen personally, I mean, I've seen it on television, I've read books, but I have never been so personally outraged in my life in a courtroom. That every single constitutional right in one fell swoop has been violated today. On behalf of myself and my clients, I have been chilled. I stood at that table, and I want the appellate record to show this when I take this up on special action, that I stood there, and I will readily admit, and I'm even upset now, that I was shaken. I was intimidated. And for a moment, I was chilled. But I'm not chilled now, because I know that I have to speak out. And when Martin Luther King was behind bars, I read his journals, and I read what he said. And he said he was proud to be behind bars. And my colleague is sitting over there in pink handcuffs, one of the finest lawyers in the state of Arizona, Your Honor. Absolutely a brilliant lawyer. And he is ethical, and he is honorable, and he is not corrupt. And I have tried cases with him. And this is outrageous. This is one of those outrageous moments in my career that I have no fear. And if you want to put me in handcuffs, you put me in handcuffs, Your Honor, because I am personally offended that this is a courtroom in the United States of America. I am personally offended. And so I am not going to apologize. I stand behind the very, very sacrosanct lawyer-client privilege that I learned in law school. I was a hearing officer for the Arizona Supreme Court for 9 years, and I learned those rules of ethics, and I went to the trainings. And when a client would violate, when a lawyer would violate the lawyer-client privilege, it was my job to discipline them. And so I know them well. And I am not going to stand up here and for 1 minute even remotely say that I would violate the lawyer-client privilege. And all I will do is say that I was in those discussions. And I will not say anything more. And this court has no right to presume that I either approve or I didn't disapprove of it. This is tyranny, what's happening today. This is not law and order. This is tyranny. I am being terrorized right now. And I am not going to be terrorized by a court. And so if you want to hold me in contempt, if you want to put me in cuffs, I wish it would be me in cuffs. Mr. Sandus doesn't belong in cuffs. He does not belong in cuffs. He's doing his job as a lawyer, and I am proud of him. And I am proud of every lawyer in this courtroom that stood up today and said, no, put me in jail, but no. And even Mr. Borges, he flew all the way over here from California. And he comes from a big firm, and he has people to answer to. But you know what? He said no. That privilege, that precious privilege is more important than me going to jail. And it was hard for him to do. So he has people to answer to. I don't. But I have my clients to answer to. And I'm proud of my clients. And the other thing I want to put on the record regarding Mr. and Mrs. Lund, Your Honor, is that this court commented on the fact that they went to the newspapers or that they spoke to the newspapers. Hello, there is something called the First Amendment to the United States Constitution. This court shouldn't be, with all due respect, this court shouldn't be penalizing anybody for talking to a newspaper or for being in a newspaper. No, that's wrong. There's the First Amendment. They have a right to do that, and that's different than being in this court. There was no gag order in place, so that is wrong, and I want to put on the record that that was a constitutional violation. And I also want to put on the record, yes, these joint agreements happen all the time, and opposing counsel had one too, with all of the lawyers and the parties, I believe, in California, and decisions were made. And so you can't penalize us, Your Honor, for just saying we were in a discussion. You don't know what view we had. And there was no evidentiary hearing, and there was no notice that we were going to be put under oath. We came here today to show